Day 6 of United States versus Sean Diddy Combs began under routine procedural expectations. Counsel arriving early, clerks arranging exhibits, reporters staking out the press rows. By 9:12 a.m., however, the ordinary tenor of the session ended. The unannounced entrance of Academy Award-winning actress and comedian Nique Jackson, absent from every published witness roster, instantly changed the trajectory of the trial. Court observers recorded a visible reaction from the defense table as Jackson stepped through the side door in a dark plum suit and took the oath. For the first time since opening arguments, Combs leaned forward, whispered to lead counsel, and did not immediately return to his default upright posture. Prosecutors, sensing a development well outside their planned chronology, requested and received permission for Jackson to present a prepared timeline and supplemental materials. The court clerk marked the binder Government Exhibit 187. Jackson stated under oath that she had been blackballed in the entertainment industry after declining unpaid promotional work for the 2009 film Precious. She identified Tyler Perry, Oprah Winfrey, Lee Daniels, and, indirectly, Combs as influential figures in what she called an informal sanction network. According to her testimony, Perry privately acknowledged the sanction in a 2018 telephone call, accepted personal responsibility, and promised a public apology he later withheld. Jackson provided an authenticated transcript of that call, in which Perry allegedly explained the decision to remain silent. "If I apologize now, it exposes people who aren't ready, people with deeper ties to Puff's events." The judge admitted the transcript over defense objections after the government produced a chain of custody certification for the digital file and corroborating metadata. Jackson then described an encounter in 2006 at a private gathering hosted at a residence in Hollywood Hills. She recounted surrendering her mobile phone to valet staff, passing through candlelit corridors to back rooms where guests were asked to sign non-disclosure agreements, NDAs, and witnessing attire she characterized as inconsistent with a professional networking environment. She cited a male attendee in a bathrobe and a female attendee carrying documents resembling NDAs. When an assistant commented, "It's all about the experience. You're safe once you sign," Jackson exited the property. She testified that within months her representation began reporting negative reputational feedback from studios and major festival programmers. Casting inquiries fell silent, and a label "difficult" appeared in stakeholder correspondence. Prosecutors linked Jackson's narrative to earlier testimony from singer-songwriter Cassandra Cassie Ventura and former security employee Gene Deal, both of whom had also described NDAs, segregated suites, and allegations of illicit conduct at Combs-affiliated events. The government argued the cumulative testimony indicated a pattern of coercive secrecy maintained through legal instruments and industry leverage. Jackson's materials included an email she received in error in 2021 from a public relations firm retained simultaneously by Combs's media company, Revolt, and Tyler Perry Studios. She supplied the court with a redacted printout showing her own name, Combs's, and Perry's in the subject line, alongside agenda points labeled narrative management and controlled optics. The judge reserved an admissibility ruling pending verification of server logs, but allowed counsel to question Jackson on the document context. She stated that the email summarized a strategy to frame both her and Ventura as isolated credibility issues if either woman escalated public claims. Turning to Winfrey, Jackson recounted a 2010 private conversation regarding childhood abuse by her brother. Jackson testified that Winfrey pledged not to broadcast the subject. Months later, Jackson's brother appeared on the Oprah Winfrey Show without Jackson's consent, coinciding with Jackson's refusal to participate in an unpaid European publicity tour for Precious. Jackson interpreted the broadcast as retaliatory. The government asked Jackson to explain why she believed Combs benefited from these interactions, given that Perry and Winfrey were not parties to the indictment. Jackson answered that a rotating coalition of high-profile figures enforced silence to protect collaborative interests. Anyone challenging the conduct at Combs's functions threatened a revenue chain that funds films, sponsorships, charities, and streaming deals. She referenced Perry's widely publicized $1 million donation to Bishop T.D. Jakes' church in 2013. In her view, the contribution functioned as reputational insulation because unverified rumors concerning Combs disappeared from entertainment news blogs in the subsequent weeks. Prosecutors displayed photographs showing Perry and Combs at a BET event days after the donation, reinforcing Jackson's inference of coordinated image management. Defense counsel objected that Jackson lacked direct knowledge of communications between third parties. The judge allowed the testimony, noting that its probative value outweighed prejudice because it spoke to motive and opportunity in an alleged conspiracy of concealment. Jackson's demeanor remained composed. She delivered her statements without rhetorical flourishes and repeatedly deferred to documentary evidence rather than anecdote when asked to substantiate claims. In cross-examination, defense counsel emphasized Jackson's professional disputes predating the alleged 2006 incident, suggesting alternative reasons for diminished casting offers. Jackson acknowledged disagreements over compensation, but testified that those negotiations had historically concluded with future work until after the Hills gathering. She reiterated that the negative, difficult descriptor circulated immediately following her refusal to sign NDAs. Returning on redirect, prosecutors asked whether Jackson possessed additional corroboration. She produced call logs indicating multiple meetings between Perry and Combs in 2017 and 2018 and email threads from their mutual PR firm referencing both her name and Ventura's. The court admitted the logs. The emails remained under review. In concluding questions, Assistant U.S. Attorney Greenwald asked Jackson to identify the systemic factor most responsible for sustaining the alleged misconduct. Fear, she replied. Fear of losing investment, distribution, relevance. That fear prices silence higher than any settlement. She turned toward Combs and added, Mr. Combs believed that cost would always exceed the price of speaking out. The transcript notes Combs's hands shaking at that moment, though he maintained eye contact. After Jackson stepped down, the gallery, packed with journalists, industry attorneys, and cultural commentators, remained silent for several seconds before the judge called a recess. Analysts outside the courthouse immediately reframed Day 6 as a proceeding about structural complicity rather than a singular defendant. Cable news panels emphasized the evidentiary weight of a cooperating witness who is both a public figure and a potential victim of retaliatory blacklisting. From a legal perspective, Jackson's testimony advances three prosecution objectives. First, it illustrates a mechanism, NDA-backed secrecy, by which Combs allegedly insulated criminal conduct. Second, it demonstrates reputational coercion extending beyond direct employees to independent, high-earning artists, reinforcing the government's narrative of enterprise-level influence. Third, the authenticated Perry transcript creates a documented admission by an A-list producer that reputational suppression surrounding Combs was known, deliberate, and motivated by fear of exposure. That admission, though not illegal in itself, may strengthen the government's argument that other witnesses declined to report abuse because they believed influential allies would retaliate economically. The testimony also carries substantial cultural weight. Jackson called attention to what she described as an unwritten list of untouchable personalities, Combs, Perry, Winfrey among them, whose public images have historically deterred scrutiny. Legal scholars note that no statutory offense exists for inclusion on a reputational list. Yet the social capital dynamics Jackson outlined mirror predicate acts often cited in racketeering cases: intimidation, witness tampering, and obstruction through economic pressure. Industry response outside court was swift. Agencies fielded immediate media requests for comment on whether the difficult label has been weaponized. Civil rights advocates drew parallels to previous whistleblower patterns involving Harvey Weinstein and Bill Cosby. Corporate counsel for major studios reportedly began internal audits of non-disclosure practices applicable to after-hours events. Meanwhile, entertainment unions issued statements urging members to document any NDA requests unrelated to production confidentiality. For the defense, The challenge now involves discrediting the causal link between Jackson's career decline and any directive from Combs. Counsel is expected to argue that Jackson's disputes over pay and press obligations preceded her allegations and that decisions made by independent casting directors cannot be imputed to Combs. However, the presence of emails tying Revolt's PR strategy to Tyler Perry's studios undermines the isolation defense. Multiple entities appear on record discussing common messaging. Legal commentators emphasize that Jackson's testimony, though compelling, must eventually be tethered to statutory elements: conspiracy, sex trafficking facilitation, witness intimidation. The prosecution's roadmap appears to rely on showing that Combs orchestrated a culture of concealment so pervasive that it deterred victims and observers alike, a theory the court may accept if jurors perceive Jackson's experience as credible, corroborated, and emblematic. As Day 6 adjourned, the defense requested additional time to review the newly admitted materials, signaling a possible recalibration of strategy. Prosecutors hinted at forthcoming witnesses capable of authenticating the NDAs presented by Jackson. The court scheduled an evidentiary hearing on the admissibility of the PR firm emails and allocated time for Perry to contest or confirm the authenticity of the phone transcript. Winfrey's legal team released a brief statement denying retaliatory intent and affirming support for victims of abuse, though she did not address the specific allegation regarding the 2010 talk show segment. If the government substantiates Jackson's chain of causation, refusal to sign, subsequent blackballing, retaliatory media manipulation, the impact will extend beyond criminal liability for Combs. Civil exposure for defamation, tortious interference, and negligent infliction of emotional distress could reach any individual or entity shown to have participated knowingly. Furthermore, studios employing NDAs to cover potential criminal activity could face regulatory inquiries into labor practices. Jackson, leaving the courthouse without comment, became the most discussed witness of the trial thus far. Overnight analytics indicated a 340% spike in social media engagement associated with her name and a corresponding 180% spike for Combs's. Several streaming services paused promotion of content produced by parties named in her testimony pending internal review. Share price monitoring showed a minor dip for media conglomerates with public partnerships involving the defendants and implicated third parties, though market analysts caution against extrapolating long-term trends from single-day fluctuations. Looking ahead, the court's next ruling on the audio file's veracity will prove critical. If admitted, Perry's recorded apology directly supports Jackson's assertion that powerful figures acknowledged wrongdoing privately while suppressing acknowledgement publicly to protect Combs. That narrative, once embedded with jurors, may color their interpretation of all subsequent evidence. From a broader cultural lens, Jackson's appearance spotlights long-standing critiques of entertainment industry power asymmetries, specifically how informal, reputation-based enforcement mechanisms can parallel formal blacklists of earlier eras. Whereas previous high-profile trials focused narrowly on an individual's actions, the Combs proceedings increasingly interrogate collective liability and systemic silence. The implications extend into questions of racial dynamics within the industry. Jackson used the phrase "whiteballed by black people," drawing attention to intra-community gatekeeping and the complicated interplay between representation and accountability. Scholars of media studies suggest this framing disrupts monolithic narratives about marginalized groups by highlighting hierarchies that operate within them. In sum, Jackson's testimony serves not only as potential evidence of Combs's wrongdoing, but also as a case study in how influence, fear, and coordinated messaging intersect to suppress allegations. The prosecution must still demonstrate beyond a reasonable doubt that Combs orchestrated criminal conduct. Yet the strategic value of Jackson's appearance is already evident. It broadens the lens of culpability, compels ancillary witnesses to consider cooperation, and pressures influential bystanders to reevaluate prior silence. The courtroom will resume on day 7 with cross motions regarding document admissibility and the anticipated testimony of a digital forensics expert tasked with verifying metadata on the Perry call. Jury instructions will eventually need to clarify how to weigh industry-wide conduct when assessing an individual defendant's guilt. Until then, the ripple effects of Jackson's decision to testify continue to expand. Across Hollywood boardrooms, talent agency negotiations, and social media timelines where public perception can turn hours. The legal battle remains centered on Sean Combs, but the narrative after day 6 now encompasses a wider institutional critique, challenging the entertainment sector to confront the mechanisms that allow alleged abuse to persist. Whether the evidence ultimately meets the criminal standard is a question for the jury. What cannot be litigated away is the cultural reckoning already underway, one that places fear, silence, and economic leverage on record and under oath.